Greetings, Torts scholars. This review provides a brief introduction to the standard classification of tort claims by the level of fault that the plaintiff must prove and the basic concept of the elements of a tort cause of action. Torts cases supply a grab bag of acts that may support liability. A kick in the shin, a chair pulled away from a person about to sit, a sinking barge, a burning haystack, an exploding package, a falling barrel, a hunting accident, water flooding a neighbor's land. These are all scenarios from memorable cases in which courts have been willing to say that a defendant's action was tortious. All of these sundry cases involve torts, but it's very difficult, if not downright impossible, to say that they all have a single set of features in common. Instead, courts and scholars have found it useful to divide tort claims into three separate categories of potential liability: intentional torts, negligence, and strict liability. These three categories correspond to differing levels of intentionality or fault that a plaintiff must establish in order to hold a defendant liable for the particular tort. Suppose Charlene, a bus driver, hits a pedestrian, Ben, and injures him. What tort claim could Ben assert to recover for his injuries? Well, we need to know more facts before we can say. Let's consider each of the three categories of torts I just mentioned. Intentional torts are claims that require proof that the defendant acted intentionally in some specific way, such as acting with a desire to harm or with knowledge that harm was substantially certain to result. In the case of Charlene and Ben, if the evidence showed that the two happened to be hated rivals and witnesses heard Charlene shout, "I'm gonna run you down," just before she hit him, well, then Ben might be able to assert an intentional tort claim against Charlene. Examples of intentional tort claims are battery, assault, false imprisonment, and intentional infliction of emotional distress, all of which are covered in separate practice-perfect reviews. Even if Charlene did not intentionally run into Ben, she may be liable for negligence. Negligence refers to the broad category of torts where the plaintiff must prove that the defendant exhibited a lack of due care or failed to act as a reasonable person would have acted in the circumstances. Ben might have a case of negligence against Charlene, the bus driver, if passengers noticed that Charlene was texting from her iPhone just before hitting Ben. Common examples of negligence include motor vehicle accidents, construction accidents, malpractice by medical, legal, and other professional actors, negligent infliction of emotional distress, and premises liability. The third usual category of tort claims is based on strict liability. This category includes tort claims that allow plaintiffs to recover damages caused by the defendant without being required to prove that the defendant had any faulty intention or lapse of due care. Strict liability applies to situations where the defendant is engaging in abnormally dangerous or so-called ultra-hazardous activities, such as blasting operations or storage of hazardous substances. This category also includes liability for injuries caused by animals and products liability claims for the manufacture or sale of defective or unreasonably dangerous products. In the case of Charlene and Ben, strict liability would not apply because driving a bus, even in a dangerous way, does not fit the legal definition of an abnormally dangerous or ultra-hazardous activity. Intentional torts and negligence are sometimes referred to as fault-based torts. Strict liability is sometimes called liability without fault because no proof of tortious intent or breach of duty is required. A fourth basis for tort liability that might be added is vicarious liability. Vicarious liability is also a form of liability without fault. It holds a defendant liable for tortious acts committed by another, even if the defendant personally did nothing wrong nor caused the act to occur. The most common example of vicarious liability is employer liability for the actions of an employee. Consider again our example of Charlene the bus driver, who injured Ben because she was texting at the time. If Ben were to sue Charlene's employer, the bus company, the company might be liable to Ben under the doctrine of respondeat superior, a form of vicarious liability. Even if the company itself did everything right, such as hiring only employees with good driving records and having policies in place to prevent employees from using their phones while on the job, the company may be vicariously liable for the torts of its employees. This type of liability is covered in a separate Practice Perfect review. I have alluded to intent as an element of an intentional torts claim and breach of duty as an element of a negligence claim. Let's take a step back and review what is meant by the elements of a claim. The elements of a cause of action are the necessary factual ingredients of a claim. The plaintiff is required to prove each element of a claim in order to establish liability. To avoid jumping the gun on our reviews of actual torts, let's consider the fictional tort of schmattery. The elements of a tort are often established by case law or statutory causes of action are spelled out in the statute. But since schmattery is fictional, let's stipulate that the elements of schmattery are that the defendant touched the plaintiff, the touching was intentional, the touching caused harm, and the touching occurred on a Saturday. If those are the elements of schmattery, that means that the plaintiff has the burden of proving each and every one of these items by a preponderance of the evidence in order to establish that the defendant is liable for this tort. Proving an element by a preponderance of the evidence means persuading the trier of fact that it is more likely satisfied than not, or, in terms of percentages, more than 50% likely to be true. Taken together, the elements of a tort are referred to as the prima facie case. Suppose Jamal sues Lang for schmattery. It is undisputed that Lang tort. Proving an element by a preponderance of the evidence means persuading the trier of fact that it is more likely satisfied than not, or, in terms of percentages, more than 50% likely to be true. Taken together, the elements of a tort are referred to as the prima facie case. Suppose Jamal sues Lang for schmattery. It is undisputed that Lang intentionally punched Jamal, breaking his nose. If this is all that is alleged, will Jamal necessarily prevail on his claim? The answer is no, not necessarily, since one of the elements of schmattery is that the touching occurred on a Saturday, and Jamal hasn't even alleged what day of the week he was socked by Lang. He may lose if it turns out that it happened any day other than Saturday. This is a silly example, of course. The point is that it is the plaintiff's burden to prove all of the elements of the claim being asserted. Conversely, the defendant can win by showing that the plaintiff's evidence is insufficient to establish any of the elements of the claim. Of course, defendants will often try to argue that the plaintiff's proof is lacking on multiple elements. Finally, if the plaintiff does prove all of the elements of a claim, it is still possible that he or she will not recover. The defendant may be able to assert an affirmative defense, which is a legal basis for avoiding liability even when the plaintiff has successfully proved the prima facie case. For example, even if Jamal proves all the elements of schmattery, He may still lose if he has waited too long to sue because the statute of limitations has passed, or if Lang can prove he acted in self-defense. But let us leave it at that, as affirmative defenses are a topic for another review.